Imagine this is a hypothetical situation. It's a normal Tuesday. You answer an email that says your manager wants to see you right away. You walk into a small conference room. Someone from HR is already sitting there. The door closes. And in less than 5 minutes, you're told your job is over. No write-up. No second chance. No 2 weeks to prepare. No warning at all. If that sounds harsh, it's because it is. But the harder question is not whether it feels unfair. The real question is whether it's legal. And for millions of workers in the United States, the answer is more complicated than most people realize. By the end of this video, you'll understand when an employer can usually fire someone without warning, when they may be crossing a legal line, the exceptions that matter, and the practical mistakes people make in the first few hours after losing a job. The part that surprises many people is this. In most of the United States, a private employer can often fire an employee suddenly, even if the timing feels cold and the decision feels unreasonable. That comes from a legal idea called at-will employment. In simple terms, at-will usually means the employer can end the relationship at any time, and the employee can leave at any time too. But that simple sentence hides a major limitation. At-will does not mean anything goes. It does not mean an employer can fire you for an illegal reason. And it does not mean every worker in every state is covered the same way. Here's where people often get confused. They mix up unfair with unlawful. Those are not the same thing. An employer can make a decision that feels abrupt, disrespectful, inconsistent, or just plain wrong, and it still may not break the law. A boss can be disorganized. A company can change direction overnight. A supervisor can decide you're not the right fit anymore. None of that automatically creates a legal claim. The law usually focuses less on whether the firing felt decent and more on why it happened, what promises were made, what protections apply, and whether the employer crossed a specific legal boundary. So if your employer fires you without warning, what is the first big takeaway? In most states, the lack of warning by itself does not automatically make the firing illegal. That is the baseline. And if you only remember one thing from this video, remember this. The legal danger for the employer is often not the surprise itself. It is the reason behind the surprise. That reason is where the real analysis begins. Let's slow that down with a simple imagined example. Suppose 2 employees are fired on the same day without notice. One is let go because the company decided to cut costs, and the person works in an at-will role with no contract protection. The other is let go the day after reporting sexual harassment or racial discrimination. Both firings are sudden. But legally, they are not the same story. The first may be lawful, even if harsh. The second could raise a serious retaliation issue. Same speed. Very different legal risk. That is why the first question is never just, did they warn me? The better question is, why was I fired, and what protections applied to me? Once you ask it that way, the situation becomes much clearer. And there are several major categories you need to think about. The first category is discrimination. Federal law prohibits firing someone because of certain protected characteristics. That can include race, color, religion, sex, national origin, disability, age 40 or older, and genetic information, depending on the law involved and the size of the employer. If the real reason for the firing falls into one of those categories, the employer can have a problem whether they gave warning or not. In fact, a company does not get a free pass just because it uses vague language like not a fit or we're going in a different direction. Labels do not control the outcome if the evidence points somewhere else. And that leads to a question many people ask. What kind of evidence matters? Usually not one single magic document. It can be comments from a supervisor. It can be different treatment compared with other employees. It can be a sudden firing right after a disclosure, complaint, accommodation request, pregnancy announcement, or medical issue. It can be a pattern. It can be shifting explanations. It can be performance problems that were never mentioned until after the employee engaged in protected activity. In other words, the law often cares about context, timing, and consistency. The second major category is retaliation. This is one of the most important areas because many workers do not realize how broad it can be. An employer generally cannot fire you for asserting certain workplace rights. That may include complaining about discrimination, participating in an investigation, requesting a reasonable accommodation, asking about unequal pay, raising wage and hour concerns, taking protected leave when applicable, or reporting certain illegal or unsafe practices. Retaliation cases often turn on timing. If an employee speaks up and then suddenly gets fired, that does not prove illegality by itself, but it absolutely raises questions. And there's another detail that gets overlooked. Some workers think they lose all protection if their complaint turns out to be imperfect, or if they used ordinary language instead of legal language. That is not necessarily true. In many situations, the law protects people who raise concerns in good faith or oppose conduct they reasonably believe is unlawful. You do not usually need to sound like a lawyer in order to trigger protection. You just have to be doing something the law treats as protected activity. Now, let's talk about something else that surprises people: discussing pay. A lot of workers still hear some version of this line from a boss: "You're not allowed to talk about wages here." That is not the full story. For many employees covered by the National Labor Relations Act, discussing wages and workplace conditions with coworkers can be protected activity. In plain English, if employees are talking together about pay, schedules, or workplace treatment as a group concern, firing someone over that can raise legal issues. This matters because some people are told they were fired for creating drama, when what they were really doing was comparing pay or speaking with coworkers about conditions on the job. The next category is contracts. At-will employment is the default in most states, but it is not universal for every worker. If you signed an employment contract that limits when the employer can terminate you, that contract matters. If the contract says you can only be fired for cause or after certain steps or after notice, then the employer may have obligations they cannot ignore. The same idea can apply if a union collective bargaining agreement covers the job. In those cases, the firing process may be restricted by negotiated rules, grievance procedures, or just cause standards. Public sector jobs can be different too. Many government employees are not treated the same as private at-will employees. Civil service protections, due process rules, and agency procedures can change the picture. That doesn't mean every public employee is impossible to fire. It means the analysis may be more structured, and advanced procedures may matter in a way they often do not in ordinary private at-will employment. Now here is the state-level exception people love to bring up, and for good reason: Montana. Montana stands out because it is not the typical at-will state in the same way the others are. Under Montana law, once an employee completes the probationary period, the employer generally needs good cause for termination, subject to the details of that law. So if someone says, "I heard every state is at will," that statement is too broad. Almost every state follows that model. Montana is the big exception people should know about. But there's another twist inside that Montana example. Even there, people can misunderstand what the law does and does not promise. A worker may still need to look at the probationary period, written policies, the stated reason for discharge, and the exact facts. So even when you hear about an exception, do not turn it into a slogan. Legal rules live in the details. This is also a good time to clear up a very common myth. If I never got a write-up, the firing must be illegal. Not necessarily. Many employees assume discipline has to move in stages: verbal warning, written warning, final warning, then termination. That may be a company practice. It may be a management preference. It may even appear in a handbook. But unless a contract, union rule, policy, or specific legal protection requires that process, the employer may not have to use it. In an at-will setting, a company can choose progressive discipline one day and skip it the next, unless doing so breaks some other legal rule. That said, handbooks can still matter. Sometimes, workers are told handbooks mean nothing. That is too simplistic. In many cases, handbook language is carefully written to preserve at-will employment and avoid creating a contract. But if an employer makes clear written promises or applies policies in a way that creates legal issues under state law, those documents can become important evidence. A handbook may not always save the employee, but it should never be ignored. If you are fired suddenly, keep a copy of the handbook or download it if you still have access. Now let's move to a different issue that often gets mashed together with sudden termination: layoffs. If one person is fired without warning, that usually triggers one kind of analysis. If dozens or hundreds of workers are cut in a mass layoff or plant closing, another law may enter the picture. Under the Federal WARN Act, certain employers generally have to provide 60 days advance written notice for covered plant closings and mass layoffs. But this law does not cover every employer or every termination. It has size thresholds, event thresholds, and exceptions. It also does not mean every layoff without notice is illegal. Still, if a large group is let go all at once, the WARN question becomes extremely important. And this is where viewers often make one of two mistakes. Some assume WARN means every employer in America must give notice before any firing. That is false. Others assume WARN never matters because they can always just fire you. That is also false. A WARN is a specialized law for specialized situations. It can be powerful, but it is not the rule for everyday one-person terminations. On top of that, some states have their own mini-WARN laws, and those rules can be different from the federal version. So what if you were fired alone, without warning, and none of those obvious exceptions seem to apply? Does that mean you have no rights at all? Not exactly. It may mean you do not have a wrongful termination claim based solely on the lack of notice, but you may still have rights involving final pay, benefits, unemployment, severance agreements, non-competes, confidentiality issues, accrued vacation under state law, or the return of company property. Losing the job is one event. Everything that happens after can be a separate legal and financial issue. Take the final paycheck, for example. Many people assume federal law requires immediate payment when you are fired. It generally does not. Federal law does not require every employer to hand you your final paycheck on the spot, but state law may require faster payment, and those deadlines vary. Some states require payment right away or very quickly. Others allow the next regular payday. That means the answer can change depending on where you work. So if you are suddenly terminated, do not guess. Check your state labor department or a reliable source for your state's final pay rules. Severance is another area packed with confusion. People hear stories about someone receiving a few weeks of pay and start thinking severance is automatic. It usually is not. In general, federal law does not require severance pay just because you were fired. Severance is often a matter of contract, policy, negotiation, or employer choice. If the company offers it, read the agreement carefully. Some severance agreements require a release of legal claims. That means you may be asked to sign away rights in exchange for money. Do not treat that like routine paperwork. Even a short document can have long consequences. And here's a practical point that matters more than people expect. Do not sign anything just because you feel shocked. A sudden firing creates emotional pressure. Employers know that. Many workers are embarrassed, angry, scared, or desperate to preserve income. That is when mistakes happen. If you are handed a severance agreement, a resignation letter, or a statement explaining why you are leaving, slow down. Read it. Ask for time. In many situations, especially when age discrimination laws are involved, there may be formal review periods. Even when there are not, taking time to understand the document can be critical. Another common myth goes like this: if they fired me without warning, I must not qualify for unemployment. That is not always true. Unemployment eligibility depends on state law and the reason for separation. Being fired does not automatically disqualify you. In many states, the key question is whether the employee was terminated for misconduct as defined by that state's rules. A poor fit, ordinary mistakes, restructuring, or inability to meet expectations may not be treated the same as serious misconduct. So if you lose your job suddenly, do not assume the answer is no. Apply and let the system make the determination. Let's go back to the emotional side for a moment because it shapes what people do next. A surprise termination often makes people want an immediate explanation. That reaction is understandable. But here's the reality. Employers do not always give detailed, satisfying, or honest explanations in the room. Sometimes they say very little on purpose. Sometimes they use general phrases approved by counsel or HR. Sometimes the person delivering the message does not know much more than what is on the script in front of them. That can be frustrating, but it also means the termination meeting itself is not always the place where the truth becomes obvious. So what should a worker do in those first hours? Start by preserving information, not by exploding. If you believe the firing may be illegal, write down the timeline immediately while it is fresh. When did problems start? What complaints did you make? Who was involved? What changed after you spoke up? Were there witnesses? Were you treated differently from others? Save lawful copies of documents you already have a right to keep, such as pay records, performance reviews, schedules, emails you lawfully possess, handbook pages, and any written termination notice. Do not hack systems. Do not steal trade secrets. Do not forward confidential client files to yourself. Preserve what is lawful and do it carefully. This matters because memory changes fast. A week later, details blur, names fade, dates drift. But the timing of events can be central to a discrimination or retaliation claim. A note that says, I requested a disability accommodation on March 3rd, was denied on March 10th, and fired on March 12th may become much more useful than a vague feeling months later that it all happened around spring. Another major mistake is venting too broadly, too quickly, especially on social media. I understand the urge, but a public post written in anger can create problems you did not need. It can escalate tensions, complicate negotiations, or hand the employer a new argument. That does not mean stay silent forever. It means be strategic first. Document privately, get advice if needed, then decide how to proceed. Here's a related point many people overlook. Being fired without warning does not mean you should automatically resign instead. Sometimes an employer pressures a worker to voluntarily resign because it sounds cleaner. But a resignation can affect unemployment, the paper trail, or how the separation is later described. If a company is ending the relationship, be careful before helping them relabel it. Again, context matters, and there is no universal script for every case, but this is exactly the kind of moment where slowing down can protect you. And what about performance issues? Can an employer fire you without warning for poor performance? In an at-will setting, often yes. They may decide you're not meeting expectations and act immediately, even if they never gave a formal improvement plan. But if the performance explanation appears only after you engaged in protected activity, or if it is contradicted by recent praise, bonuses, or evaluations, that explanation may deserve a closer look. In employment law, timing and contradiction can matter as much as the official label. And what if the company says it eliminated your position? That can be real. Businesses do restructure. Budgets get cut. departments close. But that explanation is not automatically untouchable. If one position disappears and a nearly identical role appears right after, or if only certain workers seem to be selected after raising concerns, that may matter. Legitimate business reasons exist, so do fake ones. The challenge is telling the difference. This is why a good practical question is not, can they do this? Asked in the abstract. The better question is, what facts would show this was lawful or unlawful? That shift changes everything. Instead of focusing only on the shock, you start looking for the legal pressure points: protected status, protected activity, contracts, policies, state law, timing, comparators, group layoffs, and post-termination paperwork. And let's also talk about safety complaints and wage complaints, because people often underestimate these. If a worker raises concerns about unpaid overtime, off-the-clock work, tip issues, meal breaks where protected, child labor problems, or certain unsafe conditions, firing that employee afterward can raise retaliation issues under various laws depending on the facts. The same is true if employees contact government agencies, cooperate with investigations, or assert rights protected by labor statutes. Again, the key message is simple. Employers often have broad power to fire, but not broad power to punish workers for exercising protected rights. Now, does any of this mean you should threaten a lawsuit the moment you're fired? Usually not. That can be emotionally tempting, but it is not always smart. A better first step is to collect facts, identify the relevant state, and separate three questions. First, was the firing itself potentially unlawful? Second, did the employer violate rules about final pay, benefits, notices, or agreements? Third, what practical next step protects your interests best right now? Sometimes that means filing for unemployment. Sometimes it means contacting a state labor agency. Sometimes it means speaking with an employment lawyer. Sometimes it means simply moving on because the termination was probably lawful, even if unpleasant. There's another detail many workers miss. The same set of facts can involve more than one issue at once. Suppose an employee complains about harassment, later asks for medical leave, then gets fired in a group reduction, and is offered severance with a release. That is not one legal question. That is several. Retaliation, possibly disability, or leave rights, possibly WARN, depending on the size and scope of the layoff. Possibly severance review issues. Real life often stacks these questions on top of each other. This is why broad statements online can mislead people. You'll see one comment saying, yes, they can fire you anytime for no reason. Another says, no, that's illegal if there was no warning. Both are too blunt. The more accurate answer is this. In most of the U.S., a private employment is generally at will, so sudden firing can be lawful. But it may become unlawful if it is based on discrimination, retaliation, contract restrictions, union protections, public sector rules, certain state exceptions like Montana, or mass layoff notice laws. That is the real answer. Not dramatic, but useful. So what practical checklist should a worker remember? First, don't assume no warning equals illegality. Second, don't assume no claim exists just because you are at will. Third, preserve the timeline and documents. Fourth, review any contract, handbook, union agreement, or severance paperwork. Fifth, check state-specific rules on final pay and unemployment. Sixth, look closely at what happened right before the firing. Did you complain about something protected? Request leave? Ask for an accommodation? Report safety issues? Discuss wages with coworkers? Refuse to do something illegal? Those facts can matter much more than the absence of a warning. And here's one last misconception worth clearing up. People sometimes say, if the company doesn't tell me why, that proves they're hiding something. Not necessarily. Silence can feel suspicious, but it is not proof by itself. Some employers say less because they are careful. Some say less because they are disorganized. Some say less because they genuinely do not owe a detailed explanation under the circumstances. The lack of detail may be frustrating, but frustration alone is not evidence. Focus on facts you can prove. At the same time, employers should not take comfort from the phrase at will as if it were a shield against everything. It is not. At will is a default rule, not a license to discriminate, retaliate, ignore contracts, or bypass specialized notice laws and covered mass layoffs. And that is the part many workers never hear clearly enough. The law may allow sudden termination in many cases, but it also creates boundaries. When those boundaries are crossed, the lack of warning can become part of a much bigger problem. So let's bring this back to the question in the title. Can your employer fire you without warning? In many cases, yes. Especially in private at-will employment, sudden termination by itself is often legal, but that is only the beginning of the analysis, not the end. The more important question is whether the firing was tied to an illegal reason, a protected activity, a contract promise, a union rule, a public sector protection, a state-specific rule, or a mass layoff notice requirement. If you understand that framework, you stop reacting only to the shock and start seeing the real legal issues underneath it. And that knowledge matters because the worst time to learn these rules is after the conference room door closes behind you. If that moment ever comes, the goal is not panic. The goal is clarity. Know the difference between unfair and unlawful. Know that at-will has limits. Know that timing matters. Know that documents matter. And know that one of the most important things you can do after a sudden firing is ask a better question than, was this rude? Ask, what rule, if any, did they break? That question is how you protect yourself.